Patrick Coughlin. I'm the Deputy Bureau Chief for the Cook County State's Attorney's Office in the Narcotics Section. The Cook County State's Attorney's Office opposes this bill for three reasons. One, there are appeals pending before the Seventh Circuit and the Illinois Supreme Court dealing with the eavesdropping statute. Also, this bill will have unintended consequences and is probably unconstitutional as drafted. Third, the solution lies to this problem that Madam Chairwoman spoke about with a much broader revision to the entire eavesdropping statute. As to the first point, House Bill 3944 is going to be amending a bill that the Crawford County judge declared unconstitutional 4 months ago. That case is pending before the Illinois Supreme Court, and we're waiting a decision in that case. I would ask that you give the courts a chance to speak on this issue. Basically, that judge, especially because this amendment does nothing to address the issues that led to that Crawford County judge finding the matter unconstitutional. The judge said that the eavesdropping statute was unconstitutional because it lacked a culpable mental state, that it was so broad that it punished non-private conversations, and that was not what the legislature intended. That is exactly what the legislature intended when they passed the eavesdropping statute. In 1994, there was an amendment to the language that included any conversation, whether it was meant to be private or not, was subject to eavesdropping. And that is the reason why it's illegal to record a person without having all parties consent. The Illinois Supreme Court and the United States Supreme Court both have said it's fine to do. One party to a conversation can record that conversation. In fact, the U.S. Supreme Court back in 1963 said that's the best evidence of that crime is to have the officer record it. However, because of the Illinois eavesdropping statute, officers cannot record that conversation without a court order. This is not leveling the playing field. This is giving more rights to private citizens to collect evidence of a crime than the police officers have. The Illinois Supreme Court back in '86 agreed with the U.S. Supreme Court in People v. Beardsley. It basically said that eavesdropping does not apply where one party to a conversation consents. Quote the Illinois Supreme Court, clearly our eavesdropping statute should not prohibit the recording of a conversation by a party to that conversation or one known to be present. In response, the law was changed. The bill sponsor at the time in 1994 said we are changing this specifically to address the Beardsley case. A person can't record a conversation with all parties knowing that their conversation is being recorded in Illinois, not because of the U.S. Constitution, not because of the Illinois Supreme Court Constitution. It's because of amendments in 1994 to the eavesdropping statute. The other reason why the court in Crawford County, in that case is People v. Allison, found that the eavesdropping statute was unconstitutional is because it didn't apply to all government officials. This bill addressed the secret recording or the recording without the officer's consent only. But the judge in Crawford said that all public officials should be subject to recording. So judges, clerks, public defenders, state's attorneys, any government employee should be subject to being recorded in their public duties. Not only is it premature to address this because People v. Allison is pending before the Illinois Supreme Court, there's also a case pending in front of the Seventh Circuit, and that is the ACLU v. Alvarez. That case, there was oral arguments. Justice Posner was very concerned about allowing recordings. He said secret recordings, he said, will hamper the police's ability to conduct investigations in secret, in privacy. According to Posner, and I quote, gangs will rejoice if the ACLU succeed because they can record who's cooperating with the police. Almost the exact language that the ACLU is seeking is in this bill. Victims or witnesses to a crime who want to cooperate and want to give information to the police now can have their conversations recorded. So it may have a chilling effect on victims coming forward if they know that a person who's not a member to that conversation can come up and record whatever they say to the police. This bill is going to have unintended consequences. More people will likely be charged with eavesdropping, not less. People will think that it's okay to record the police and my conversations with an officer. However, you record an officer in your home, it's still a Class 1 felony because that's not a public place. You record that officer on the front lawn, and now because of this amendment, it's not a crime. Officer pulls you over, you record him while you're sitting in your own car during a traffic stop, that's not a crime. You get arrested and the recorder's still running in the police car, that's not a private place anymore. That's a Class 1 offense. How are people going to know what's the definition of a public place? The front counter of a police station, yeah, that's public. Interview rooms are private. Courtrooms, though, those are public places. And there's several different definitions of what a public place is. There's one in the curfew statute, there's one in the public indecency statute, there's one in the Smoke-Free Illinois Act, and now we have a fourth definition. There's going to be an increased danger in stops. You're going to have situations where people are reaching into their pockets and pulling out a black object and pointing it at the officers. We have already had people killed because officers thought that they were pointing a gun at them when actually it was a cell phone. Police are going to be seizing a lot more civilians' phones because the police cannot record conversations without a court order. However, if you have your recorder going during a DUI stop or during some other crime, that phone, if your recorder was going, now has evidence of a crime. And that could be seized either pursuant to a warrant or because of some exigent circumstances, because the recording could be erased, or as part of the booking process.